Hi, everyone. Thanks for joining us today. On behalf of Farella, Braun, and Martel and the Environmental Law Institute, I'd like to welcome you to this installment of the Unplugged Renewable Energy Series. My name is Nick Moore. I'm an associate at Farella, Braun, and Martel in the Environmental Practice Group and the Energy and Natural Resources Industry Group. In the past, we've done these events in person at our office on Montgomery Street, where we'll usually start with a few refreshments and some networking. But for obvious reasons, we're doing this remotely today. But we appreciate you joining us, even without there being a happy hour this time around. We have some fantastic panelists here today to discuss our topic, the PG&E Bankruptcy, Lessons Learned, and a Path Forward. This is part 2 of our series on the PG&E bankruptcy. Part 1 was back in March of 2019, shortly after the company declared bankruptcy. So now that PG&E has emerged from the Chapter 11 process after crafting an approved reorganization plan, we wanted to reconvene and discuss how that process unfolded, its implications for the energy sector, particularly renewable energy, and what lies ahead. So we're planning to have a relatively informal roundtable discussion for about 45 minutes to an hour. And then at the end, we'll do some Q&A. So please stick around until the end, and then feel free to ask any questions that you may have at that time. You can also feel free to type any questions into the chat, and I'll read those at the end. But we request that you keep yourselves on mute until that time. As I mentioned, we have some really great panelists today, and we're appreciative that they're taking the time. So I'm going to introduce each of them now. First, we have Bill Mannheim. Bill Mannheim is a senior director and counsel in the PG&E Law Department. He heads the Law Department Strategy and Policy Group, which provides advice and counsel to numerous divisions within PG&E. Bill recently completed a 1-year rotation as Senior Director of Bankruptcy Restructuring, where he helped develop and obtain regulatory approval of PG&E's Chapter 11 Plan of Reorganization, which is, of course, our subject today. So we're very happy to have Bill. In this capacity, Bill worked on legislative reform to wildfire liability laws, which culminated in the adoption of SB 901 and AB 1054, both of which we'll be talking about today. Bill joined the PG&E Law Department in 1987 after graduating from law school at UC Berkeley. We also have Ralph Cavanna, Energy Program Co-Director at the Natural Resources Defense Council. Since joining NRDC in 1979, Ralph has focused on removing barriers to cost-effective energy efficiency and on the role that electric and natural gas utilities can play in leading a clean energy transition. From 1993 to 2003, he served on the U.S. Secretary of Energy's Advisory Board. He has taught energy law and policy at a number of law schools, including Harvard, Stanford, and UC Berkeley. He is currently a board member of the Bipartisan Policy Center and vice chair of the Bonneville Environmental Foundation. He also chairs the advisory board for the UC Davis Energy and Efficiency Institute. And Ralph is a graduate of Yale University and Yale Law School. Next, we have Jared Elias. In addition to being a new dad, congrats, Jared. Jared is a professor of law and faculty director of the Center for Business Law at the University of California, Hastings College of the Law in San Francisco. In the spring of 2018, he was visiting associate professor at the Boston University School of Law. And then prior to joining Hastings, he was a teaching fellow for corporate governance and practice at Stanford Law School. His research interests are corporate bankruptcy, corporate governance, empirical legal studies, financial markets, and commercial law. He's a graduate of the University of Michigan and Columbia Law School. Last but not least, we have Gary Kaplan. Gary's a partner at Farella, Braun, and Martel and chair of Farella's Restructuring, Insolvency, and Creditors' Rights Practice Group. He has decades of experience representing debtors, creditors committees, trustees, and receivers in a wide range of bankruptcy and non-bankruptcy matters. His practice includes both out-of-court and Chapter 11 restructurings, He counsels companies and individuals experiencing financial and operational challenge in myriad industries, and he has extensive experience in insolvency-related litigation. He's board certified in business bankruptcy law and is a certified legal specialist in bankruptcy law by the State Bar of California. Gary is a graduate of the University of Pennsylvania and UCLA School of Law. So we're going to start now by giving each panelist the floor to give some opening remarks and get us started. So I think we're going to start with Jared. So Jared, take it away.
Great. Well, thank you so much, and thank you to everybody for coming. It is great to see all of you, even if we can't actually be together. So before I get into my remarks, I just want to clarify. So when PG&E was in bankruptcy, I advised various members of the state senate and the state senate itself. I testified a couple of times. I'm here speaking on my own behalf, not on behalf of anybody else other than me as an observer. So one of the things that I found the most remarkable about this bankruptcy, not knowing very much about this company as much as it's part of our daily life here in Northern California, was what a complicated company this is for anybody to run. It may be the most complicated company on the planet. I guess that's a hard statement to falsify, but this is a really, really interesting situation. So it was the largest utility bankruptcy of all time, but before it became the largest utility bankruptcy of all time, it's a company that's simultaneously a privately owned public utility, a company that then has to look to Wall Street to raise money, an employer of, I think a little less than 20,000 workers here in California, one of the largest companies in the world. It's a tool for clean energy mandates and for California's leading role in helping to develop clean energy. And it's simultaneously accountable to Wall Street, Sacramento, the legislature and the governor's office, various federal agencies, the California Public Utilities Commission, customers and ratepayers, including leading corporations here in California, and an incredibly diverse base of consumers who live in very diverse environments. It also has another role, and that's as an insurer of last resort for people who live in fire-prone areas, areas that have become more fire-prone over the past 10, 15 years or so, when the fire starts as a result of PG&E's equipment, right? So PG&E is forced by law to effectively insure all of those people. And that led into why this company had to file for bankruptcy. There were massive fires that you all know a lot about, so I won't go into them. But in 2017 and 2018, it created thousands of fire survivors who then looked to PG&E to make good on that, because even if PG&E had not been negligent, PG&E was still strictly liable as an insurer of last resort under the way California law works to make all of those people whole. So when the company filed for bankruptcy last year, it had spent, according to public court documents, over $90 million defending itself in litigation from all of these various fire survivors, many of whom lost their homes, they lost their businesses, they lost all of their possessions, and the company filed for bankruptcy needing relief and needing breathing room in order to reorganize. And I think at that I can hand it off.
Bill, would you mind taking it from there?
Thanks. Hello, everyone, and it's good to meet you. I want to open just by acknowledging the devastating toll the 2017 and 18 fires had on the impacted communities and the wildfire survivors and victims. PG&E has acknowledged its responsibility and accepted accountability for its actions, but there's no way to make the communities and victims whole. We believe that the wildfire settlements that were reached as part of the bankruptcy process are a reasonable and fair outcome, but it's the impact of this is something that the 20,000 employees at PG&E live with every day. And, together we are striving to improve our operations and make sure as best we can that this never happens again. I wanted to provide just a quick overview of the plan of reorganization that was approved. I'll keep it high level, and I know we'll dig in deeper as we get into the questions. Most importantly, PG&E's plan of reorganization provided for $25 billion worth of settlements with the wildfire constituencies. So that included, for the wildfire victims, $6.35 billion in cash and approximately 22.5% of the outstanding equity stock in PG&E Corporation. Those amounts were contributed to a trust, and an independent trust administrator has been appointed to work through distribution of those settlement amounts to all of the claimants. We also had a separate $1 billion settlement with the cities, counties, and public entities that were affected. And finally, an $11 billion settlement with the insurance companies that paid claims to the businesses and the residents that were impacted by the fire. As a result of the plan, there will be no increase in rates to customers. And in fact, because we were able to effectively refinance our debt load at significantly lower interest rates, customers will receive approximately a $250 million a year savings compared to what our debt costs were going into bankruptcy, which is kind of amazing when you think about it, that we came through this bankruptcy with a lower cost to customers. PG&E is able to participate in the going forward state wildfire liability fund, which we'll talk about in more detail later. But this was something that was created by AB 1054, which addresses the risk associated with future potential wildfires, and it was a critical element of our exit. And our plan included a $5 billion contribution funded by shareholders as part of the initial upfront funding of that fund. Our plan, we were able to assume all collective bargaining agreements, employee agreements, pension obligations, so employees are held harmless through the plan. And importantly, with respect to the state's clean energy, PG&E has prided itself on being a leader and a strong progressive advocate in the state's clean energy strategy. And the bankruptcy plan didn't impact that significantly. Our first day motions allowed us to continue to participate in the state's programs, continue funding, continue administration. Now, I know there was some uncertainty with respect to the treatment of power purchase agreements, which we'll talk about later today, but ultimately all power purchase agreements were assumed, and all amounts owed during the pendency were paid on time. The plan pays all pre-petition claims, and through our plan, PG&E has committed to enhance our safety, reliability, and accountability. And there are a number of things that we'll be doing differently, but just to highlight very high level, we can come back to this. Our governance and operations has changed significantly. Perhaps someone could mute, I'm hearing some feedback, sorry. The Public Utilities Commission has implemented a new enhanced regulatory oversight process, which we'll talk about. We have a state-appointed observer that is now working with us as we approach the fire season. We have agreed to appointment of an independent safety monitor that will take place once our federal monitorship expires. We've established new chief risk officer and chief safety officers, senior positions reporting directly to the CEO. We've enhanced our risk management process. We've created an independent safety committee that is reviewing our operations. We've also committed not to reinstitute our common dividend for a period of years until we've retained enough income to retire approximately $4 billion in debt. We've committed not to seek rate recovery of any of the amounts paid to victims for the 2015, 17, and 18 wildfires, with the exception of the securitization, the rate neutral securitization proposal we have before the commission, which we can talk about in a bit. So the plan overall positions PG&E to receive investment, both equity and to be able to raise debt to pay for tens of billions of dollars in system hardening and wildfire risk mitigation in the coming years. And I think exiting bankruptcy, being positioned to really improve our operations was a critical factor. Thank you.
Thanks, Bill, for that informative overview. Ralph, I know that you had some opening remarks that you wanted to make.
Sure. Jared and Bill have set the stage very effectively. Let me just say a word about NRDC's role in this process, and I hope many of you view NRDC as your favorite hometown environmental organization. We are a national and international enterprise, but we have had a very strong presence in Northern California since 1972, when the Western office of NRDC was founded by a man named John Bryson, who I'm expecting many of you know. He went on to become the CEO of Edison International. That is not a typical NRDC career trajectory. And when I walked into NRDC in 1979, I assumed that I would be spending my career in good part suing PG&E, an impression further reinforced by the fact that when I walked in the door, PG&E's senior management was being deposed in the NRDC conference room as part of what became a landmark Supreme Court decision on California's nuclear power regulatory system. So the initial years of my service at NRDC did meet that expectation, but things then changed, and PG&E became gradually over the years, to my immense gratification, a significant and constructive presence on a whole host of clean energy issues. I think that Bill is right to say that the company in recent years has positioned itself as an essential clean energy partner, but there were moments of very severe challenge to that, the first of which came in the 2001 to 2004 PG&E bankruptcy, when PG&E at that time was the nation's largest investor in energy efficiency and renewable energy. And the company's revenue streams supporting those functions, and all of the funds also supporting low-income energy services, were seized by PG&E's creditors at the outset of the 2001 bankruptcy. And it required NRDC's first intervention in a utility bankruptcy proceeding was with PG&E in a motion to free up those funds, which mercifully was successful after only a three-week freeze. So in the 2001 to 2004 bankruptcy, PG&E was able to reestablish its clean energy investments, but only after an interval of paralysis that was potentially devastating for a whole host of businesses and also for PG&E's own capacity to maintain its trajectory toward energy efficiency, renewable energy, and a path into a decarbonized future. That process was even further advanced by the time PG&E's second bankruptcy began in 2019. A critical difference, however, and Bill mentioned this, was that PG&E was able from day one to protect those investments. Now, that we'll have discussion later in the session about the renewable energy contracts, and they were important, and NRDC supported continued payments of those contracts and is glad that those payments were sustained. And they were on the order, I believe, Bill, of $2 billion a year. But an almost equivalent amount of money was going into low-income energy services, weatherization, energy efficiency investment, and a whole host of electrification initiatives that were part of the core of PG&E's decarbonization efforts. Those investments also were preserved from day one and continued through the process. We will talk about other ramifications of the bankruptcy proceeding. I don't think for a moment that utility bankruptcy assists any part of the clean energy transition, but it is notable that this bankruptcy only occupied 18 months, I think to the astonishment of everyone involved, possibly even the legislators who set the deadline that helped drive that process. And it is notable also that PG&E kept its word on its clean energy commitments and exits bankruptcy with a new set of commitments that were a critical part of the plan of reorganization. And I'll look forward to further discussion of that as we continue.
Thanks, Ralph. Gary, if you had anything you wanted to add to that, please go ahead.
Well, tough act to follow. I'll try to be brief. So I'm Gary Kaplan. I'm a partner here at Farella, as Nick mentioned. I was actually involved with the first PG&E bankruptcy case back in 2001 at my prior law firm. I was one of the main attorneys on that case that, believe it or not, is still going on, because it involved, in that point, was dealing with the large California energy crisis of 2001, which engendered a lot of litigation about manipulation of the markets through by Enron and the like. And that litigation, some of it is actually still going on to this day, and therefore the bankruptcy case has not been closed. But I think more relevant to today, in terms of the current case, is that the PPA or power purchase agreements we've been talking about, those are still a hot button item in a lot of utility bankruptcy cases, and frankly, in a lot of gas company bankruptcies that are now ongoing as a result of the fracking industry collapsing. And we're going to be talking about the fact that that issue, which is whether the bankruptcy court has sole jurisdiction or whether FERC has concurrent or exclusive jurisdiction to allow parties to terminate or get out of contracts that FERC regulates, is still a really important issue in the energy industry. And in fact, I've been involved with another utility case in Ohio called First Energy Solutions, dealing with very similar issues that happened in the PG&E case as to whether the bankruptcy court and or FERC has the power to make the final decision when a debtor wants to get out of those power purchase agreements in bankruptcy. As we'll be talking about, that case, just like the PG&E case on that issue, went up to the Circuit Court of Appeals, the Sixth Circuit in that case, the Ninth Circuit in the PG&E case. And even though in the PG&E case, economically, it's not going to make a difference, the actual litigation is still ongoing. And in fact, the Ninth Circuit is set to hear argument next week on the decision the bankruptcy court made on the PPAs, or power purchase agreements, that we're going to be talking about shortly. Thank you.
Thanks, Gary. That was a lot of great information, so thank you, everyone. We're going to jump into questions now and go a little more deeply into a lot of the issues that our panelists have raised so far. So obviously, one of the big issues surrounding the bankruptcy was liability for wildfire impacts. And then, of course, the new legislation that has been passed in the last couple of years to try and mitigate future impacts. So Jared, I know you were pretty close to this issue. I was wondering if you could talk a little bit about how the company's reorganization and the CPUC approval will ensure compliance with the recent wildfire legislation, SB 901 and AB 1054.
Sure. So one of the things that made this bankruptcy so unusual was the role of the governor and the role of the state legislature in shaping the way that the plan came together. So something that I found absolutely fascinating was the way that the only precedent I can think of for a bankruptcy where a government was as involved with PG&E as involved with a different large company as they were with PG&E is the GM bankruptcy. And there, the Obama administration used its role as debtor in possession to sort of force the outcome that they wanted. The state legislature, essentially through AB 1054, was able to shape the boundaries of the plan of reorganization. So AB 1054 said, for example, that fire survivors needed to be paid in full, in line with the state legislature, with the importance the state legislature placed on making sure that the victims of the 2017 and 2018 North Bay fires did get paid, as much as PG&E could possibly pay them. But by passing that law, it essentially meant that PG&E was going to come out with a solvent debtor plan. And that's what PG&E did. PG&E came out with, everybody is going to get paid in full. And you could have done a different plan under bankruptcy law if you had wanted to, but the company was from the very beginning committed to this legislative structure that the governor and the state legislature set in place. So AB 1054 created a wildfire insurance fund where the government put essentially, the shareholders of PG&E, if you look at who contributed to it, the shareholders of the big utilities in California all contributed to a insurance fund that can be tapped in the future by all of by the major utilities that are part of this fund if there are future fires that they need to then pay large damages out of. That is the broader trade that the governor kind of orchestrated, which was, you get insurance, and in exchange, there's a structure put in place. You have to be out of bankruptcy by June 30th, 2020. You have to do all of these extra things. And it was pretty amazing as an observer watching PG&E sort of rise to the challenge of meeting those deadlines and meeting all of the challenges that were put in front of them. There was a very arduous regulatory proceeding before the CPUC that I don't want to get too far deep into that rabbit hole. I think others may want to talk about it as well. But the role played by the governor in this case is really extraordinary. And the sort of stages of this bankruptcy case, I'm currently working on writing something about it. And when I look back at my notes of what happened, the letter in December saying, from the governor saying, we think that the plan needs to change. You need new governance. You need a new board of directors. You need all of these other things. Sort of the interplay between the bankruptcy court and what went on in Sacramento is just extraordinary. And I think it will be talked about by bankruptcy scholars, for decades to come.
Thanks, Jared. Bill, did you have anything to add there? I know you were, very much involved with, I believe, even crafting that legislation itself, but also, of course, working out how PG&E would ensure its compliance going forward.
Yeah, it was quite a challenge to put a plan together under the circumstances of the legislature's influence and the Public Utilities Commission, and it started right off the bat. So SB 901 had a provision that was a worker protection clause that basically said if there's a change in control in a utility, before that change in control can happen, you have to provide 15 days advance notice. And it defined a bankruptcy filing as a change of control. So PG&E was the first entity, probably ever in history, to provide 15 days advance notice that it was about to enter bankruptcy. We had to comply with the law. So one of the key protections, and Jared and Gary can talk about this more of any bankruptcy proceeding, is the automatic stay. That goes into effect the moment you file, and it creates a period where you can create kind of an orderly process for how you're going to go about resolving your claims. But PG&E, by being required to provide 15 days advance notice, basically told all of our creditors, all of our PPA counterparties were about to breach. And as a result, many of them took action in advance to protect their own interests. So we were scrambling like crazy in the 15 days before we filed to ensure the continued flow of power and the continued flow of gas. Because we had entered an event of default under those agreements, because as soon as we announced our intention, our credit rating was dropped and we fell below investment grade, which was an event of default. So we were threatened effectively with being cut off entirely with our gas supply, which would have caused cascading outages throughout Northern California. We were able to negotiate prepayment arrangements and pay-as-you-go, and negotiate security deposits to keep that continuity of service. But it was an incredibly challenging 15 days. And once we got in and filed those first day motions, it was actually a relief because we knew the lights would stay on. Jared, mentioned that the other key lever the legislature used to influence the bankruptcy process was AB 1054 and the eligibility requirements for participating in the Go Forward Wildfire Liability Fund. And he mentioned a few of the restrictions. One was we had to have a confirmed plan by June 30th. Secondly, we needed to pay wildfire victims in full, or at least settle with them, or have those claims estimated and pay the full amount. Third, our plan needed to be neutral on average to customers. so no rate increase. And it also gave the commission, it basically said the commission must approve our plan, the Public Utilities Commission, our plan and all plan documents. So which effectively gave the PUC complete control over the terms and conditions over whether we could participate in the wildfire fund or not. And President Batcher provided an assigned commissioner ruling with a number of restructuring requirements that PG&E accepted, and they were litigated through a Public Utilities Commission process. But the pressure of the bookends, right? 15 days notice before, and we had to be done within 18 months. We had to settle all claims in full within that time period, not leaving much time for an estimation process to occur, really made it challenging. We also had the complexity of competing plans, a continuing federal monitor, and a very active governor. So altogether, I'd say it was a tremendous challenge, not just for PG&E, but for all the participants in the proceeding. And most of these disputes were resolved through settlement, almost all of them. So the parties did rise to the occasion, came together, particularly once shelter in place hit, and worked these issues through under the timeline. So it's really an achievement for the bankruptcy process and the way all these factors came together.
Nick, if I might just add one word, this is Ralph. NRDC supported SB 901 and AB 1054, and I agree with Jared and with Bill that those bills had the effect of helping the legislature and the governor be at least equal partners with the bankruptcy court in managing PG&E's path forward. It is important, however, to recognize that there is one thing those bills did not do. They did not adjust the fundamental liability structure that thrust PG&E into bankruptcy. And as a consequence, a concern that I think all of us need to share is Bill Manheim pulled many rabbits out of a hat to do something I think he accurately described as paying off $25 billion of claims, getting the company back on its feet, not raising customers' bills, and effectively reestablishing PG&E as a financially viable force. I'm not sure he can do it again. That is, what AB 1054 does is to create a $21 billion fund. Half of that fund is paid for by continuing a pre-existing charge on all customers' bills. So it did not all come from PG&E shareholder contributions. But that source of funding is now subscribed. A $21 billion fund has been created, which, as we know, is enough for one massive wildfire. And the question remains, and from NRDC's perspective, there is still more work to be done to establish a workable liability process that doesn't simply assume that California's electric utilities will be, as Jared put it, the insurers of wildfire liability costs going forward without limit and regardless of the reasonableness of their conduct. So from our perspective, that's unfinished business. From the perspective of everyone involved in this process, because future wildfire victims won't be well served by a liability system that thrusts the presumed payers immediately into bankruptcy again.
Yeah, and just to add something to what Bill said, I thought that narrative was a great description of the overall arc of things. And one thing that as a bankruptcy lawyer is very interesting is that the AB 901 15-day limit, where PG&E had to give 15 days notice before filing for bankruptcy, as a matter of bankruptcy law, that may not have actually been enforceable. And when PG&E sort of signaled that they weren't going to take that hard line, read of the legislation and file for bankruptcy anyway, and they would put up with that 15 days of disruption, it really set the tone for the bankruptcy case, where PG&E was really looking to be constructive as a debtor in possession and not fight to the death like some debtors in possession are currently doing. Go see Neiman Marcus down in Houston at the moment. But it really set the tone for the bankruptcy case. The PG&E came out clearly looking to use this period productively and not to fight everyone to the death, which is would have been a misuse of Chapter 11 under these circumstances.
Great. Yeah, it sounds like, Bill, you probably weren't busy at all the last year and a half. That's what I'm getting. So, Ralph, I know this is a topic of particular interest to you, but I think to a lot of people in this virtual room, if you will, and that's, how does the reorganization impact PG&E's commitment to clean energy policies?
And for those of you who want to see the commitments themselves, they are in the testimony of Jessica Hogle, which was presented by PG&E at the close of the CPUC proceedings to approve the plan of reorganization. What that testimony includes is a comprehensive set of commitments that certainly have the potential to reestablish PG&E's clean energy leadership. And to just hit a few of the highlights, PG&E has been, over the course of the past quarter century, the largest investment, not just in the utility sector, but in the United States, in the broad suite of clean energy solutions, starting with energy efficiency and renewable energy. Coming out of the bankruptcy, PG&E's commitment is to drive toward decarbonization at or ahead of the statewide goal of 2045. To do that by maintaining its energy efficiency leadership, a couple of aspects of that commitment that I think are particularly important and not well known are that PG&E is the strongest single utility sector coordinator and advocate for energy efficiency standards in California, which are at the heart and soul of what we've been able to do to create clean energy momentum and efficiency momentum, not just in the United States, but across the United States. Not just in California, but across the United States. PG&E is going to continue that leadership role, continue its leadership role in institutions that are vital to efficiency progress. And PG&E in general, what you'll see in these commitments is not important so much in dollar terms, although there will end up being dollars that will be allocated by the PUC through its integrated resource planning process. But it is about leadership. It is about a commitment to decarbonization that led PG&E to be the first utility in the country, the first combined gas and electric utility to support building standards that push new construction toward all-electric applications, efficient all-electric applications, and remove the natural gas infrastructure altogether. That's absolutely critical, as is the fact that the commitments include something that NRDC put an enormous amount of effort into, and I think some on this list did too, which is PG&E's long-term commitments on the retirement and replacement of Diablo Canyon. Those also feature prominently in the commitments. That's an important part of the reorganization plan. It brought NRDC to support of that plan before the PUC. And I do think that it's going to be a critical part of what we should be using to gauge the success of the whole reorganization enterprise.
Thanks, Ralph. If anyone has anything else to add, please go ahead. Otherwise, another question that we wanted to be sure to talk about was the reorganization's impact on long-term power purchase agreements, or PPAs. I know this was something that came up a lot during the process, and that gave a lot of parties certainly some level of anxiety. So, Gary, if you want to take this one to start, please jump in. Ben.
Sure. Thanks, Nick. So before the case got filed, as Bill mentioned earlier, a lot of parties had a heads up that PG&E was going to file bankruptcy, and they took various actions to try to protect themselves against that. And various parties that have power purchase agreements with PG&E filed proceedings at FERC, Federal Energy Regulatory Commission, to try to prevent PG&E from unilaterally trying to reject or terminate those contracts through the bankruptcy process without also going through the FERC process, because most of these contracts are FERC jurisdictional, meaning that they are implemented through the Federal Power Act, and FERC has authority to authorize any changes to them or authorize the termination of those contracts. And in fact, FERC issued orders right before the bankruptcy was filed saying just that PG&E would have to go through the FERC process in order to get out of these PPA or power purchase agreements, and could not do it solely through the bankruptcy process. So that led to, when PG&E filed the bankruptcy case, it filed its own lawsuit against the various parties that had brought the proceedings at FERC and against FERC itself to try to stop those proceedings at FERC and to get the bankruptcy court to say that the bankruptcy court and only the bankruptcy court would be the sole decider as to whether PG&E could seek to reject and get out of those contracts. And the key is, it wasn't clear that PG&E wanted to get out of any contracts, but it just wanted the flexibility to be able to do so. It didn't want to have to go through the bankruptcy process only to be told later on that it couldn't get to the aim that it might need, which was to try to terminate some of these contracts. So it really wanted to get sort of a head start on the process. And after a lot of litigation in the bankruptcy court found that indeed it had the sole ability, the sole jurisdiction to determine this issue, and that as long as it complied with various bankruptcy code provisions that govern this procedure, that it was the sole arbiter of determining whether PG&E could reject these contracts, and FERC had no say in the matter. And in fact, the bankruptcy court enjoined FERC from engaging in any proceeding related to the contract termination or adjustments to the contracts. And this got appealed up to the Ninth Circuit Court of Appeals. That, in this case, all the parties agreed to bypass the Intermediate Appellate Court, which is the district court, or the bankruptcy appellate panel. Parties have a choice, and go right to the Ninth Circuit. And the matter actually is pending right now at the Ninth Circuit. It's been fully briefed. It's going to be argued next week. You know, the facts on the ground ended up making a lot of these issues moot, in terms of PG&E ultimately determined it did not need to reject these contracts, and in fact is going to assume all of them through its bankruptcy plan, and therefore there was no reason, you know, to continue with the appeal. So PG&E is trying to get that appeal dismissed, but it also wants to have the FERC proceedings that it started out right before the bankruptcy dismissed as well as moot, and that's really the issue that's remaining before the Ninth Circuit is what to do about these pending appeals. And I should have mentioned, the real reason why those appeals ended up being moot is that the advantage of PG&E potentially rejecting these agreements would have been if PG&E was not paying creditors in full. The advantage of rejecting an executory contract like a PPA is that the contract, even though the contract claimant has a claim for damages for breach based on the future amounts owed under the contract, that claim is treated as a pre-bankruptcy debt, just like other pre-bankruptcy debts, and oftentimes pre-bankruptcy claims do not get paid in full. In fact, in the vast majority of cases, they get paid a fraction of the dollar. So the idea would have been, if PG&E was going to not pay creditors in full, it could have tried to get out of some of these more burdensome contracts where the market price now is much lower than what PG&E agreed to pay under the contracts, and saved a lot of money, because then it would have had to pay a claim at a lot lower amount. And in fact, that's indeed what's gone on in this Sixth Circuit case that I'm involved in with First Energy Solutions. Similar thing, they try to get out of contracts, although in their case, they were paying claims at about 30 or 35 cents on the dollar, so they had a real benefit from being able to reject these contracts and essentially pay the amounts owed at a fraction. And in fact, I was one of the parties that appealed the bankruptcy court's order allowing these contracts to be rejected. And just like the PG&E bankruptcy court did here, the bankruptcy court in that case said FERC has no role to play in this proceeding, and the bankruptcy court had sole authority to determine that issue. The Sixth Circuit said otherwise and reversed the bankruptcy court on this and sent the proceeding back down to the bankruptcy court on the grounds that the bankruptcy court should have at least heard from FERC and let FERC provide input in terms of the factors that usually go into the FERC proceeding to determine whether a party can get out of a FERC jurisdictional contract. Most of those go to the so-called public interest in terms of figuring out how the termination of the contract is going to affect the overall energy markets and the grids that are constantly accepting energy from both the buyers and sellers, and sort of more of a big picture role than looking at any individual contract counterparty. So the Sixth Circuit sent it back down to the bankruptcy court to use this new standard that's different than the standard that the bankruptcy court in the PG&E case used. And it turned out since then we've settled. So now that issue won't be decided in that court either. But the reason it's important, and the reason that FERC keeps pressing this issue, is that it's very concerned with how circuit courts may rule on this and how the Ninth Circuit might rule on this, because there are now a number of other bankruptcies going on, both utilities and gas suppliers that have similar contracts that FERC also regulates. And the issue is, if it turns out that FERC does have a role to play, meaning that the bankruptcy court does not have the sole authority to let a debtor reject and essentially walk away from an energy purchase contract, that can have a lot of implications in the markets. For example, parties may be less willing to enter into long-term energy supply agreements, whether it's gas or electricity or anything else that FERC regulates, if they see that their counterparty might file bankruptcy and use that as a lever to get out of the contract. Or more likely, what some parties will do is use the threat of rejecting the contract as a way to renegotiate the deal. And that, the energy markets obviously are sort of shuddering at the possibility that their long-term contracts may not be respected, and they may have to, think about differently how they do business. And in turn, those energy sellers who are getting financing based on having a stable asset, a steady supply of cash based on a specified pricing mechanism over a long period of time, all that is called into question if the underlying contracts can be rejected and the stream of payments goes away. The lenders in this area are going to be more reluctant to lend money to energy sellers or parties that own these power plants. So these contracts, have really wide-ranging implications, even though in this case it didn't end up really mattering to PG&E itself. PG&E paid everybody, didn't reject the contracts, and ended up, sort of walking away with the issue becoming moot in this case. But it certainly is a hot-button issue for people in the industry, and I know that others, particularly Jared, has been following this issue closely, and certainly would want to hear from them on their viewpoint on this.
I have a couple thoughts as well. I don't know, Jared, if you wanted to weigh in here, but I think one question we get is, well, if you're going to assume the contracts and you're committed to the state's clean energy goals, why fight the fight? So I think we need to go back to when this all played out, which was in those first 15 days before we'd even filed. And NextEra and followed by other utilities filed preemptively at FERC before we had even filed bankruptcy seeking a declaratory order. And what FERC ruled was that, well, yeah, the bankruptcy court has authority to reject contracts, but FERC also have authority over these contracts. So FERC envisioned a two-step process where you would need to get approval. If a debtor wanted to reject a contract, you would need to get approval of both the bankruptcy court and FERC under the public interest standard, which is a very difficult standard to achieve. On the day, in the days before we filed, we faced tremendous uncertainty, and we did not know if we were going to be a solvent debtor. We did not know the extent of the damage claims. No claims had been entered. So the uncertainties facing us were tremendous, and we really weren't in a position at that time to say, okay, we're going to give up any rights through the bankruptcy court to seek to reform or reject power purchase agreements that we may not need anymore. So we had to preserve our position and our flexibility as we went through the bankruptcy process, and that's what we did. And now I think the issue before the Ninth Circuit, we have two separate appeals that are being coordinated, the FERC order and the bankruptcy court order. Our view is that both orders should be vacated, that the issue is moot, and that we should return to the status quo ante. And that, effectively, because no contracts were rejected, there is no need to establish new law through this case. So, and the Ninth Circuit has indicated that the oral argument is going to be focused solely on the vacatur issue. So they don't seem to care about the merits of the question. They're only going to be addressing whether the orders should be vacated or not. At least that's my understanding. Jared, do you have thoughts?
I think Gary and Bill have done a great job covering this, so I won't add very much other than it's really one of the fascinating questions of the jurisdiction of the bankruptcy court. And to me, the right answer is probably that the bankruptcy court can reject these contracts without needing FERC to be involved in that process. You know, bankruptcy law typically beats non-bankruptcy law. And at the beginning of the bankruptcy case, when PG&E first, sought permission, or they first sort of tussled with FERC about whether or not they would be able to do this on their own, it did look like one of the storylines in this bankruptcy might be, those PPAs where maybe there was some cost savings that would be possible. Given the structure of the plan, that would never have made any sense, just given that PG&E paid all of its unsecured creditors in full. So tearing up bad contracts only makes sense if you're not going to pay those people in full because they get a rejection damages claim. But this is a great example, I think, of one of the ways in which PG&E used Chapter 11 in a very judicious and specific way, where the company could have decided that they wanted to try to force savings on power suppliers, and they didn't do that. And they had the legal tools, and they chose not to. So it's a very unusual Chapter 11 in that way, because most of the time a debtor in possession really does fight to use every tool that they have to come out of bankruptcy with as little debt as possible. And PG&E took a different approach, and it'll be fascinating watching that play out as we move through the next few years.
Switching gears a little bit, and sticking with you, Jared, I know something that you were paying a lot of attention to was Governor Newsom's role in the bankruptcy case. I wonder if you could talk a little bit just about how his involvement affected, both the process and, the ultimate reorganization.
Sure. So I'll preface this by saying that, my knowledge of Governor Newsom's role is really limited to what was public, what I could learn from reading the newspaper and reading the tea leaves. So obviously there's more out there that I don't know, because I'm pretty sure that as busy as he was in the bankruptcy court, and he hired O'Melveny and Myers and appeared in the bankruptcy court, which I think is, as far as I know, is a first for a sitting governor to, go hire a very expensive law firm to fight it out in bankruptcy, on his own behalf, not on behalf of the state government or any particular state agency. And it went to how committed he was to using bankruptcy to try to help with the public policy dilemmas that PG&E's current structure creates. Governor Newsom, was deeply involved from the very beginning, and the bankruptcy plan that came out is something that, to a large extent, he owns. And in a world where we didn't have COVID-19, when he first assumed office, you thought that one of the most important items, and perhaps the most important item of his governorship, was going to be what do we do about PG&E and the various North Bay fires and all of these issues. And he definitely played a leadership role in steering it through AB 1054 and through everything else. And, I think that, for all we know in public, I think there were many, many, many backroom negotiations in Sacramento where he was, putting his hands on this, in every part of the bankruptcy case and moving this company along into a structure where he was comfortable not only with how they were going to emerge from bankruptcy, but also regulating the company going forward. The new procedures that were put in place at CPUC, they dramatically shifted the regulatory landscape for PG&E over the next several years. And, Governor Newsom was deeply in the weeds negotiating all of those things. And it's really an unprecedented, intervention by a sitting governor in a Chapter 11 case. But with that, I'll let other people talk. If there are other comments on Governor Newsom's role.
I know Bill was privy to a lot of those, behind the scenes conversations with.
That's who I was thinking
Governor,
of.
but I know.
I can't talk about them.
Yeah.
But I will say, the governor had a very clear plan, and he stuck with it and was very forceful in his advocacy. He shaped the plan, and I think as a result, it brought parties together and allowed for the resolution. I think the influence of the governor was a really significant and positive one for this all working out.
I agree with that, but I think it is also important to underscore the role of the legislature. And Assemblyman Chris Holden, Senator Dodd, those who shaped these bills were equally a part of steering this in ways that state legislatures normally can't and haven't in bankruptcy. And I think ultimately that was highly constructive. It did not accomplish everything that we hoped it would, but without it, we wouldn't be here.
Yeah, and something that we should add to that is Judge Montali was incredibly deferential to the signals he was getting from Sacramento throughout his administration of the bankruptcy case in a way that is also a little bit unusual. Normally, bankruptcy judges are very muscular in sort of asserting their authority over the debtor, but Judge Montali definitely understood the importance of the state, legislative structure to any plan of reorganization. And when the governor asked for things, and when the governor expressed his view, the governor didn't always get everything, but Judge Montali signaled again and again that you are somebody I'm listening to. He also did that, by the way, with respect to the fire survivors. The fire survivors were represented in this case in many different ways, and Judge Montali always went to enormous lengths to give that constituency their day in court and to make sure that he was listening to them and paying attention to all the things that he was concerned about. So that was really, quite an important piece of this bankruptcy case, which is not, by the way that, a bankruptcy judge in, let's say, Wilmington, Delaware, might have managed this company had the company chosen to file there. We really got through this bankruptcy process a judge who is deeply respectful and deeply focused on PG&E's critical role, for the state of California and for everyone who lives here. Governor Newsom's role in his leadership role in the bankruptcy and the leadership of, obviously, and that was a great point, Ralph, members of the state legislature really only, was underscored and reinforced by the way Judge Montali managed this case.
We might want to remind everyone, Jared, that this was not Judge Montali's first PG&E bankruptcy either.
That's true. And there were times when, if you looked at who was in his courtroom, it did have a little bit of an air of getting the band back together from the last bankruptcy 20 years ago. Where a lot of, very important bankruptcy lawyers here in Northern California, got critical formative experience working on that PG&E bankruptcy from 20 years ago. And at the beginning, I think there was a great deal of confusion about whether or not, this was kind of the same thing again, but it was a completely different set of issues and a completely different, bankruptcy process. I think people recognized that very quickly, but there was a little bit like, here we go again, and we just hope that there's not a third one anytime soon. I think with AB 1054, hopefully there won't be, but the points that Ralph raised about resilience and sustainability of PG&E's overall enterprise are really important. Like, PG&E did not leave this bankruptcy with a solution to the liability problem. They left with, a better tomorrow than what yesterday was, hopefully, but the solution will come from other places.
Yeah, one other thing I was going to add about Governor Newsom, I think he was also effective in creating a lot of leverage in terms of, if PG&E did not both get its plan confirmed by June 30th and have it become effective soon after that, he was able to negotiate provisions, and these are publicly available, that required the company to switch to a sale mode if it could not get its plan effective shortly after June 30th. And I think that lever there, that risk that the company might be liquidated after all, is something that pushed them very hard to get a plan both confirmed and take all the steps to have it become effective very quickly. And I think that pressure exerted, just like the pressure from the legislature to get in order to access the wildfire fund to get a plan confirmed by June 30th. I think both those things really, move this case to a much quicker end than we would have seen without those levers in place.
And to your point, Gary, if I recall, one of our first conversation on this potential panel was back in June, and a major topic at that time was, are they going to meet the deadline? Well, it's 6 o'clock, so I think we'd like to open it up now to Q&A. So